It's an honor and a privilege to have Attorney Holley with us today. Attorney Holley Geerdes is one of the best, trial and estate planning attorney in the United States when it comes to protecting assets. By the way, she's also my attorney as well. So we know how great she is. You know, all over the country. Her highly successful and legal career started in the state's government, and where she was appointed to monitor and litigate the most important legal issues and developing in the front of the highest state courts. So without further delay, I'll give, the floor to Attorney Holley and, she could introduce herself and start her presentation. Attorney Holley, please take it away.
Thank you, Kanika. And I want to make sure I can share my screen. Let's see here. I can share my screen. Okay, can everybody see my screen here? Okay, can everybody see my screen?
It's coming up. Yes.
Okay. So my name is Attorney Holley Geerdes, and I own the law firm Estate Law Center USA. It has over 23 locations, and we specialize in wills, trust, and probate court for those that don't end up getting a trust before they die. And I want to congratulate all the graduates today. This is such an important graduation because no matter what you do, no matter how hard you work, no matter how successful you are, if you don't have the basic knowledge to your assets and finances and understand when you get expert advice, you're not successful. All successful people always have basic knowledge on the financial literacy that you've been learning in I think the last 5 weeks. Is that correct, Kanika?
Yes.
That is
You
correct.
still need expert advice that does it every day, but you still need to have the basic foundation to be able to actually control the outcome and how your assets and your life and your family all play out, depending on your knowledge and your expertise on financial literacy. Now, my area of practice is the law, but it intersects with financial professionals because you guys help to build your assets and your clients' assets if you're going to go into this profession. My job is to work with financial professionals to make sure that everything that they worked hard for is protected during their life and after their death for a legacy for their family, their children, their grandchildren, and even great-grandchildren. You can't take your assets with you, so you need to make sure that you leave your assets in the right legal manner instead of the government taking over the assets, which is what happens to most people, even in the United States. So I want to just go over just the basic rules today. There's a lot more information and details, and I hope in your financial journey, you will take the basic information and learn more for yourself first, and then hopefully whatever business you do, hopefully, maybe in the financial business, because you can make a lot of money in this industry the right way. But hopefully you'll take this information, you will learn more and share this information with all your family and friends in your community. Now, for those that attend this webinar today, if you have any further questions, feel free to contact me. Because you're graduating today, and because of everything that the organizers of this presentation and graduation do for you and for everybody in the community, I don't mind answering further questions after today for yourself and for your family. So you can just take a snapshot of the QR code. And if you've got any further questions or you want to learn more, go ahead I won't charge you. You can just link within this QR code to contact me directly. Now, in the United States, what are the rules regarding your assets in the event of two events that I deal with every day? One is if you or your parent or your family ever has dementia, stroke, brain damage from diseases, cancer, car accident, who controls your assets? And the other event that we deal with is death. When you go on to the next life, you can't take your assets with you. So, again, with the rules when you're alive, and then we'll go into the rules after you pass away. Now, when you're alive and you're healthy and you're mentally competent, you control your assets. However, some people at a later age get dementia, Alzheimer's, Parkinson's. Some people get in a car accident and get permanent brain damage. I've seen people with strokes, chemotherapy, diseases damage the brain. And when you don't know what's going on and cannot control or make this, you only have two options in the United States. Either the probate court, the government takes over you and your assets. They try to help you, or you execute the right legal documents to appoint trusted family members or friends in the United States. They can't be out of the country. That's not practical anyway. So if you don't want probate court taking over under those circumstances, and it could be 50 years from now when you're 100 years old, but the two legal documents essential is the financial power of attorney and the healthcare directive. The financial power of attorney is where you legally appoint a family member or friend or friends to manage your assets for your care if you ever have incompetency issues or you're incapacitated or in a coma. If you don't appoint somebody and that happens to you, the government takes over and they appoint somebody for you. Just like Wendy Williams. We're going to talk about Jay Leno quick. But before we go into that, the other second document is the healthcare directive. That is somebody that you appoint to make your medical and life and death decisions if you are incapacitated. These two documents allow you to avoid the probate court from taking over and making decisions financially, legally, and medically. Now, Jay Leno, talk show host, 350 million assets, half of it he put in his wife's name jointly, but she got dementia. He didn't have a power of attorney. He didn't have a healthcare directive. He didn't have a trust. He didn't have a will. He had nothing. So where did I say you end up if you have those legal documents? Probate court. So he had to hire a lawyer to go to probate court. And now the probate court supervises half of his assets because his wife has dementia until she dies. And then probate court takes over after death. And we'll talk about that, the next step. So what are the rules after you pass away? Well, there aren't many options. So let's go over what happens when you have no will, no trust. What happens if you have a will? And what happens when you have a will and a trust? When you procrastinate or you have nothing, guess what? The government decides who receives your assets. Probate court takes 1 to 2 years. The average cost is 5 to 15% of your assets. And you have, again, no control or say as to who gets your assets. The government decides. And it's not automatically 100% to spouse. It's not automatically 100% to the children. Every state law is different. But the point that I want to emphasize is when you die and you have nothing, You just gave it to the government for free. Now, if you've got minor children, they take over all the assets of the minor children and the children, and they appoint who's going to have physical custody, and they will control the assets and spend it until the child is 18. And then they give everything all at once, whatever's remaining, that is, to the 18-year-old in one check. Prince had nothing, no will, no trust. He died with $300 million. All of it was eaten up in taxes, probate court, and whatever little remained, the future royalties, went to his stepsister, who he had a restraining order against. So when I say you have no control over who gets your assets, well, Prince is a perfect example. He had a restraining order against his stepsister, and she ended up getting the future royalties. Now, what happens if you just have a will? A will is a good start. A will is a good start. But for most people, if they own real estate or they have minor children, it's not enough. The will is not valid until it's filed in probate court, and the probate judge decides whether the will is valid or not. We have to notify everybody in the universe, did this person owe you any money? We have to go through 1 to 2 years of probate, same average expense, 5 to 15%, according to the AARP. So then it begs the question, well, why the heck do I need a will then if it's the same legal process as? Well, the only difference then is at least you have a legal document, assuming nobody objects, assuming that the judge says the will is valid, assuming we can find the original will. At least you have told the court, these are the people I want to receive the assets. However, everyone has to unanimously agree on the terms of your will. If anybody objects, you have to litigate it. So in reality, this is shocking. Having a will is sometimes more expensive than having nothing at all. And the reason for that is many people challenge a will. When you have no will, no trust, the government already has rules of who gets your assets. You can't challenge that. That is set by law. But the will can always be challenged. No exception. Now, same thing with minor children. You can name a guardian in your will for your minor children, but the court still has to approve that. And it has nothing whatsoever to do with the assets that you leave for minor children. The probate court takes over those assets because minor children cannot receive assets. It either goes in probate court or you do a trust. So we'll talk about that next. Now, if you've got any assets like a house that has a mortgage and the house has to go through probate because you don't have a trust to avoid probate, the house has to be sold to pay off the mortgage in full. Total up everything you own, multiplied by no less than 5 to 15%. And when you hopefully eventually get a trust, then you can compare the cost. And Kanika knows there's no comparison. The cost of a trust to avoid this probate cost is very minuscule compared to the cost of probate. Now, when I talked about that a will can be challenged, people are shocked. Why the heck can my will be challenged? Because that's the law in the United States. In fact, we have to ask everybody in the universe when probate's open, does anybody challenge this will? James Brown had a perfectly valid will to grandchildren for education and the rest to underprivileged children for their education. Everybody not listed in that will, which was his family, challenged the will and they won. They got the bulk of it because it was too costly to litigate. And, you know, he was leaving for charity and his grandchildren, they were little children, so they couldn't defend themselves. So as long as you understand that a will can be challenged, you have to decide, do I want to go route where it's guaranteed that I control how this plays out? Or do you want to just go the quick, easy way and the cheapest way in the beginning? But in the end, it is the most costly option. The trust ends up being the cheapest, the quickest, the most confidential way to transfer your assets without any challenges. It's a legal document like a will, where you list who gets your assets and who's going to distribute it at your death, who's going to manage the assets in the trust if you ever get dementia. But probate court has no control or jurisdiction over a trust document. You control the outcome of what happens to your assets and family when you use a trust. Now, if you've got minor children, because they can't receive assets, they can receive assets through the trust, and you can appoint a trusted family member to manage the assets until your children turn 18, 21, 25, whatever age you feel that they can take control of the trust after you die. Now, when you create a trust, you create it. You control everything as a trustee. You're the beneficiary during your lifetime. You do whatever you want with the trust. You and the trust, by law, are one and the same during your life. When you die, it springs into action to transfer your assets to the people you list in the document instead of probate court. Now, in the document, you're going to list, because you will die eventually, who's going to manage the trust and who's going to distribute the assets to my beneficiaries. And once you sign and notarize the trust, when it's complete, you're not done. Your trust is empty. You gotta put your assets into the trust, including your business. Otherwise, anything left outside will go through probate. The only exception is bank accounts, investment accounts, retirement accounts, life insurance, where you can designate an adult beneficiary. That will avoid probate. If you've got minor children and you list their names, it's got to go through probate. If you've got minor children that you're leaving life insurance, you should list the trust as the beneficiary so that the money doesn't get turned over to probate court. Your children will receive, as minors, still the money through the trust. Once you do everything right and you fund the trust correctly, when you pass away, as soon as you take your last breath, your beneficiaries, your family, will receive instantly. They don't have to go to court. They don't have to go hire a lawyer. They are literally the next owner of the assets that you designated for that particular person. The problem we have now is the do-it-yourself trust. People think that by inserting a name, that's going to work. It does not. The biggest segment growing in probate court, making attorneys a lot of money like me, is the do-it-yourself trust. You cannot imagine the type of trust, this do-it-yourself that we get in probate, where people think that that's actually going to work by having a template that millions of people use. It isn't even tailored to you. You don't even know what the terms mean. And somehow you think that this is going to work. The one thing that you should never, ever, ever risk is your assets and your family. That is the most important decision that you will ever make at the end of your life as to how you are going to leave your assets and whether you did it correctly or not. Now, Michael Jackson had a do-it-yourself trust. Where do you think that ended up? Yeah, it's still being litigated after 16 years. And it's even more costly, probate court, when you have a defective trust, because attorneys get to litigate more with a defective legal document. Now, the most popular trust is the revocable trust. You can revoke it, you can terminate it, you can change it, Everything in the trust is yours. You do whatever you want. And then at your death, this document transfers assets automatically, instantly, privately, no further cost to your family. The middle trust, and for financial professionals in here, you're going to run across clients that want to protect their assets from lawsuits, like doctors, motel owners, gas station owners. So they do a second trust to put assets in here in case if they ever get into a lawsuit, this trust bulletproofs their assets in this trust from any lawsuits. Some people will use the same middle trust to plan for Medicaid, long-term care costs, if they don't qualify for long-term care insurance, because you always want to try the best option that gives you the best quality of life, and that's long-term care insurance. I'm not an expert in that, but I'm assuming through the financial literacy, your journey, you're going to learn about it. The number one reason for bankruptcy now is due to long-term care costs. It's not people defrauding people or owing $1 million. No, it's long-term care costs. So there are sometimes people that can't qualify for long-term care insurance. They will do an irrevocable trust to try to get on Medicaid in the future and not have to spend down all their assets. And finally, for financial professionals in your journey, you're going to come across people that they have enough assets where the federal government and some state governments will tax their assets ranging from 16 to 40% above the state or federal tax threshold. Now, in conclusion, if you're thinking about doing your will and trust, think about your spouse, think about your children. In the event your spouse remarries, your spouse ends up in a nursing home, your children get divorced or sued or bankrupt or disabled themselves. The trust allows you to make any rules you want in protecting your assets during your life and after your death for your surviving spouse and children. Think of your trust as a family vault. Nobody can get in and out of that trust except you during your life. And then when you die, you pass the key to that vault to whoever family member you are transferring your assets in the vault, called the trust. And you can shield it and bulletproof it from any life events like lawsuits, creditors, remarriages, divorces, probate court, estate taxes, any life events. That is entirely up to you. You can be in control of how this plays out. But it starts with you being educated in financial literacy. And part of that journey now, as you tell from tonight, how to protect your assets for yourself and your family. Now, I want to again congratulate all the graduates. I promise you, you learning the basics of financial literacy is leading you towards financial freedom and success. And I wish all the best for you. And I hope at one point I meet all of you again.